On July 23, 2025, a significant day in Indian legal history, the Supreme Court of India, the nation's highest judicial body, issued a landmark directive, a decision that reverberated across the country's legal landscape. This directive mandates a 2-month freeze on arrests, a temporary suspension of immediate detentions, specifically after an FIR is filed under Section 498A of the Indian Penal Code. This section deals with cruelty against married women. This isn't a repeal of the law, but a pause, a crucial distinction to understand, meant to prevent immediate arrests, offering a buffer period before any action is taken. The aim is to encourage mediation and facilitate dialogue in family disputes, providing an opportunity for reconciliation. The move responds directly to growing concerns about the potential misuse of the law, addressing issues raised by various stakeholders, which was originally designed to protect women from cruelty and harassment within their marital homes. However, it has sometimes been allegedly used to settle personal scores or as a tool for harassment. Now, police are mandated to wait 2 months before making arrests in such cases, allowing time for assessment. This provides families with a crucial chance to resolve issues amicably, potentially avoiding lengthy legal battles. This is all done without the immediate trauma and social stigma associated with immediate detention and arrest. The Supreme Court's ultimate goal is to protect the innocent from wrongful arrest and potential harassment, ensuring justice is served fairly, all while ensuring that genuine victims of cruelty and harassment still have unimpeded access to justice and legal recourse. It's a bold step, a significant departure from conventional practices, shifting the primary focus from immediate punishment to reconciliation and amicable resolution of disputes, especially in sensitive family matters where relationships and emotions are deeply intertwined. Section 498A, a significant addition to the Indian Penal Code, was introduced in 1983. It was hailed as a breakthrough law, a landmark moment in the fight for women's rights. Its primary purpose was to protect married women from cruelty of all forms, including dowry harassment, physical violence, and insidious emotional abuse that often went unchecked. Its power lay in the provision for swift, often warrantless arrests, a deterrent intended to send a clear message. This sent a strong message throughout society. Domestic violence is a serious crime, not a private matter to be swept under the rug. But as time passed, troubling reports of misuse began to surface, casting a shadow over the law's initial promise. Entire families, sometimes with members completely uninvolved in the alleged abuse, faced arrest, prolonged legal battles, and devastating social stigma. The very strength of the law, its ability to act swiftly, gradually became its greatest weakness. It risked turning a shield meant to protect vulnerable victims into a sword wielded for personal vendettas and settling scores. Courts have since struggled to find the right balance, ensuring robust protection for women while simultaneously preventing the misuse that leads to legal harassment. The Supreme Court's new directive represents the clearest and most decisive attempt yet to restore that delicate balance. It aims to curb the misuse of the law effectively without weakening the crucial protection it offers to genuine victims of domestic abuse. The Supreme Court's directive builds on the Allahabad High Court's earlier reforms. The High Court pioneered a 2-month cooling-off period and mandatory mediation before any arrests in 498A cases. Family welfare committees were introduced to mediate and assess complaints, aiming to resolve disputes outside police stations and courts. The Supreme Court has now adopted this model nationwide, standardizing the process across India. This shift prioritizes reconciliation and fairness, ensuring that only serious cases proceed to arrest. It marks a move from automatic punishment to thoughtful intervention in family conflicts. At the heart of this reform are family welfare committees. These committees represent a significant shift in how we approach sensitive family matters within the legal system. They are comprised of neutral community members who step in to mediate every 498A complaint, offering an alternative to immediate adversarial proceedings. Their role is to facilitate understanding and find common ground. After an FIR is filed, the committee is given a defined window of 2 months to conduct its review and mediation efforts. During this period, the committee's primary objective is to hear both sides of the story, carefully considering all perspectives. The aim is to foster dialogue and understanding, encouraging resolution through communication rather than immediate legal action. Following their investigation and mediation attempts, their unbiased report provides crucial guidance to the police. This report helps determine whether an arrest is truly warranted, ensuring a more considered approach. This measured process is designed to protect the innocent from hasty arrests, preventing unnecessary hardship and potential injustice. Simultaneously, it gives genuine victims a formal community-backed review of their grievances, ensuring their voices are heard and their concerns are addressed. The success of this system hinges on the committee's integrity, impartiality, and comprehensive training. If implemented thoughtfully and effectively, it could fundamentally transform how family disputes are handled within the legal framework, promoting healthier resolutions. The goal is clear: making arrest a last resort, a carefully considered option, and not the default first step in addressing family conflicts. Ultimately, this reform seeks to make justice more compassionate, balanced, and fundamentally fair for all individuals involved in these sensitive cases.